morning. Welcome to our brief regular session. Today is Wednesday, February 18th, 2026. We will be going into executive session, and then we reserve the right to come back into public session.
Chair, I have a point of order.
Okay.
Thank you, Chair. According to Oregon Ethics Commission, Chapter 199, Division 40, the executive session, a public official is supposed to be notified within 24 hours of a public body, public officer, an employee, or staff member, or individual agent the opportunity to request an open hearing under ORS 192.602B or I. The public official must receive written notice of the meeting no less than 1 business day or 24 hours, whichever is greater, in the advance of the meetings. I have not received that to date, so I'm calling this as a point of order that was not followed. So pursuant then to ORS 192.6602B, I'm requesting an open meeting to consider the allegations that I have violated Lane County personnel policies. An executive session is currently planned pursuant to ORS 192.6602B to consider the dismissal or disciplining of, or to hear the complaints or charges brought against a public officer, employee, staff member, or individual agent who does not request an open hearing. However, as I prepared for that meeting, it became clear to me that I'm unable to meaningfully respond to an investigative condensation or defend myself because I have not been provided the full investigative report as required by due process. The other commissioners who will be considering the allegations made against me have also been denied the full investigative report, including evidence which further violates due process. I request an open meeting after the full report and evidence has been provided as required by law. I would also like my attorney, Jill Gibson from the firm Gibson PC, to make additional comments pertaining to this issue during this public proceeding. Thank you, Chair.
Thank you, Commissioner Lovell. Counsel Klein, I'm going to look at you for some direction here.
Can the commissioners hear me?
Yep.
Okay.
Yeah, it should be live.
I believe Commissioner Lovell was received notice of the hearing through his then attorney, Luke Reese. That notice specified that indeed he could request that the portion of today's session that is under 192.660(2)B to be conducted in open session. To sort of set the stage of what today's session was intended to cover, I'll just note that on February 1st, Mountain Lake's employment investigation completed its investigation. On February 2nd, Commissioner Lovell was notified of the outcome of that investigation and the fact that each of the allegations that the investigator had investigated were sustained. On February 3rd, the board met in executive session, the outcome of which was a direction for me to prepare a condensation and to provide that condensation to affected parties, including Commissioner Lovell, by February 9th, and that was done. The board also directed the county to release condensation to the public on February 10th, and that was done. And the purpose of today's meeting was to hear from Commissioner Lovell regarding the sustained allegations and for Commissioner Lovell to be provided with an opportunity to provide any information that he believes the board needs in order to decide on a path forward. It's correct that the commissioners have not received the entirety of the investigation. If the commissioners direct me to provide them with that, I will, of course, comply.
Okay. Commissioner Lovell, I don't know your attorney's name.
My attorney's name is Jill Gibson.
Jill Gibson. Jill Gibson, would you like to weigh in on this? Yes, please come to the podium.
I object.
Yeah, we have a point of order here, too, I think.
Why is that?
Well, maybe, and we also have counsel Lori Cooper online in terms of, for procedural matters. So just looking for, this was not what was noticed, that there would be public comment section. I'm just asking for clarification and also want to make real clear who's speaking and who they represent and who is someone the county or commissioners have directed be engaged in this work or not. So I'm just looking for some clarification before we proceed, because there was no public comment or anything of the kind noticed as part of this meeting.
Right, but I guess also part of my concern is Counsel Klein said he believes that Commissioner Lovell was notified through an attorney. So I guess we don't know if that happened. I was going to ask Jill if we knew that it happened.
I don't believe he said through an attorney. It was publicly noticed.
No, he said,
This is not a place for dickering.
Yeah, I'm just asking for a procedural clarification on the
and I'm just stating the words
board
he said.
meeting government side from our attorney who's here to guide us on that.
Mr. Klein, were you going to respond to something before this is Lori Cooper.
Just as a point of clarification, my understanding is that Ryan McBride also sent directly a copy of those notices to Commissioner Lovell. And those were sent on February 9th.
I have questions from Mr. Klein. When at the appropriate time?
Chair, is
I think we're,
it okay if I sit? My eyesight's not what it used to be.
sure, let's see what Lori has to say about this, because
It's the board's prerogative. I mean, this is not a time for public comment unless, it sounds like Commissioner Lovell has asked that this session be held in open session. So that would be the time for, I heard the word objection. That would be the time for objections and discussion about process. But I would caution the board not to get into too much public comment right now until we proceed into until we proceed into the quote unquote hearing for the personnel matter.
thank you. Point taken. Appreciate it. Go ahead, Commissioner Farr.
Well, first I'll weigh in on this. This doesn't seem like public comment. This is a disciplinary process against an employee, against the commissioner, who has, in my estimation, should be allowed every opportunity to speak for himself prior to going into a closed session. An attorney is a part of his voice at this point in time, so I think we should hear from the attorney. That's that one. But Mr. Klein, my question for you was, February 10th, the investigation, the summary of the investigation was released. When did the board give the authority to release that on February 10th?
The board, my understanding was that the board gave direction on February 3rd to release it, and then that direction was confirmed for me on February 10th.
Which was the date of the release?
Yes,
And February 10th was what day of the week? Was that a Tuesday?
I believe it was a Tuesday.
It was a Tuesday. So you received authority on February 3rd to release it at that point in time.
Yes,
And when the authority was given, it would be released the day prior to the executive session. At which point, after the executive session was changed, the decision was made to go ahead and make the release on the approved date, not on the approved timing in regards to its position with the executive session.
my understanding of the direction that I had received was that it would be released to the public on February 10th, which was also the day that was scheduled for executive session. I sought clarification and provided commissioners with information as to what I had understood the directive to be, and when I didn't receive a new directive, I complied with the directive as I understood it.
You've made that clear. Thank you, Mr. Clark. That's all. Thank you.
Have you had a chance to review the executive session?
I have not.
Okay. I'll leave it at that. So at this point, Jill Gibson, I believe it was.
Thank you. I'm Jill Gibson. I represent David Lovell. I just want to briefly address Commissioner Lovell's right to request an open hearing on these allegations. That's from ORS 192.660, subsection 2B. There's no time limitation for his request. And the legislature's silence on that means he can request that at any time. There are other statutes in the open meetings law and executive session laws which do contain very tight deadlines. So the legislature knows how to impose a deadline if that's what it wants to do. There's no deadline on this request, so my opinion is that his request now for an open meeting is effective. I have other comments in general about the investigative process, if you want me to continue on with those, or do you want me to pause at this moment?
Well, let's get some direction to make sure we can have a open meeting here, and if we can, let's proceed.
I'll defer to Lori Cooper on that.
Yes, I think Attorney Gibson's correct. There is no timeline. Employees or commissioners in this case can request an open hearing at the moment executive session is to start. So yes, we can start the open session.
Okay, and I believe we had instructions from Mr. Klein on how this was to proceed.
This is really Commissioner Lovell's time to provide the board with the information that he believes it needs.
Okay, thank you. To you, Commissioner Lovell and Ms. Jill Gibson.
I'd like my attorney, Jill Gibson, to proceed on, Chair. Thank you.
Yours.
As I said, Chair, I've been retained by Commissioner Lovell in this matter. I have reviewed generally the process that this board has used over the last few months in investigating allegations against the commissioner. I have reviewed this condensation report, which in my opinion is a joke, and I will get into my reasons for that in a minute. There are numerous legal problems which have occurred in this process. And today is not the time to go through all those problems that I see, but I want to raise 3 general problems. First, the allegations against the commissioner in the investigation are premised on the belief that the Lane County Administrative Procedures Manual applies to elected officials. It does not. Those are policies that were created by staff. Lane County, as you know, is a home charter county. The only personnel rules that apply to elected officials are the ordinances and the rules passed by this body. The Lane County Administrative Procedures Manual was not passed by this body. That applies to employees, not to elected officials. So the investigative report is premised on an incorrect belief that the policies apply here, and they simply do not. Oregon courts have consistently recognized that counties cannot use personnel policies to usurp the statutory authority of elected officials. In one case, Bishop versus Oregon, the Oregon Supreme Court noted, quote, "The Curry County personnel rules cannot be enforced against elected officials." Staff members cannot draft personnel policies to impose discipline on the very elected officials that control that staff. Commissioner Lovell, as an elected official, is accountable to the voters, not to staff-written personnel policies. In another case, Young versus State, The court said that elected officials are fundamentally different than employees and that they, quote, are not under the authority or charge of any supervisory person or entity other than the electorate itself. The Ninth Circuit has also weighed in on this. In a case that you might be familiar with, Boquist versus Courtney, this occurred in 2019. It was in the newspapers. You probably are familiar with it. In that case, some Republican state senators decided to leave the state capitol to deny a quorum. The Senate President, Peter Courtney, issued a directive to the state police to locate the state senators and arrest them and bring them back to the Capitol. Senator Boquist made two statements. First, he said, Mr. President, he said this on the Senate floor, Mr. President, if you send the state police to get me, hell is coming to visit you personally. He also said, if you send the police to get me, quote, send bachelors and come heavily armed. I am not going to be a political prisoner of the state of Oregon. In response to these comments, which were threats of violence, the Senate's Special Committee on Conduct met to consider a workplace harassment complaint for making threats of violence. The committee determined that Senator Boquist violated workplace rules, and he was put on a safety plan that required him not to enter the Capitol without giving 12 hours advance notice. He was also fined. Senator Boquist brought a lawsuit in federal court alleging that he had been retaliated against for exercising his First Amendment rights. The state issued or filed a motion to dismiss, and Senator Boquist prevailed. The Ninth Circuit stated, I'm going to quote here because it's very important that I get these words correct. The Ninth Circuit stated, elected officials have an obligation to take positions on controversial political questions so that their constituents can be fully informed by them and may be represented in governmental debates by the person they have elected to represent them. The court went on to say, elected officials have the right to enter the field of political controversy, and the role that elected officials play in our society makes it all the more imperative that they are allowed to freely express themselves. The court decided that they are aware of no other case that upheld the expulsion or exclusion of elected officials from their office due to protected speech. Yet that is what has happened here. Commissioner Lovell has been put on a safety plan and prevented from coming to this office by staff. And he was put on that safety plan because he wrote a salutation in a birthday card that said blessings, something that he had no idea would be found offensive to the person he was writing the card to. A word that any reasonable person would not take offense to. So that is my first point, that these rules do not apply to Commissioner Lovell as illustrated by the Boquist case and those state court cases I cited. The second major problem I see with this investigation and the process is that Commissioner Lovell's freedom of speech has been violated. Every alleged violation noted in this condensation of the investigation is premised on something that Commissioner Lovell said. And the county cannot discipline him for something he says. The voters put him in this office, and only the voters can exclude him from this office. Thirdly, even if the personnel rules did apply, there are numerous due process problems with the investigative process. As you know, a summary of the investigative report with conclusions was provided to the public before Commissioner Lovell ever had a chance to respond in writing. That's just basic due process, that the accused has the right to respond to the allegations made against him. He was denied that in this case. He has been denied the investigative report. He has been denied the evidence against him. Yet this board was prepared to go into executive session today and have him defend himself. He doesn't know what he's defending himself against other than these summary conclusions. Secondly, there are numerous factual inaccuracies in the report that was released to the public. And there's evidence that these factual errors were known before it was ordered to be released. It was released anyway. That violates his right to liberty interest. This report, the condensation, when I read through it, I was really shocked. It's premised primarily on a definition of retaliation. The investigative report on page 9 through 10 has a definition of retaliation because the personnel policies contain no definition of retaliation. It says you can't retaliate, but it doesn't say what that is. Again, that's basic due process. You have to put people on notice of what they cannot do. You can't make the rules up as you go along, which is what's happening here. The investigative report has a definition of retaliation, and it quotes it. There's no citation. You learn in the first week of law school to cite authority. This whole report is premised on this definition. It does not state where this definition comes from. So that's a big problem. Then the report goes through the sustained findings. Again, everything that Commissioner Lovell supposedly did wrong was premised on protected speech, such as saying blessings in a birthday card. The report concludes that he violated policies by speaking to the public. Again, he's an elected official. That's what he's elected to do, is speak to the public and speak to the media. That's why his voters elected him. He's apparently in violation for the grade he gave the county administrator. That's his job. The county administrator serves at the pleasure of the commissioners. The commissioners have the authority to hire him and fire him. And you have the authority to rate his work. The administrator didn't like the score he got. That's Commissioner Lovell's prerogative to give him the score he wants to give him. And the administrator claims that it was retaliation for forwarding complaints to HR. That's incorrect, and that's something that the commissioner will discuss in open meeting. He will discuss the exact reasons why he gave the county administrator a low performance score. Condensation also concludes that Commissioner Lovell violated policy by defending himself. Again, this is due process 101. People have the right to defend themselves to the public, to the media, to their friends. So let me be very clear. Commissioner Lovell has very strong legal claims that the investigative process violated his rights to due process, freedom of speech, freedom of religion, his liberty interest. And I have advised him to file a lawsuit. I don't say that lightly. Many times I honestly advise clients not to file a lawsuit because I don't like to lose. And I don't like clients to pay me money if I think they're not going to win. I don't have those doubts in this case. I encourage the board to have an attorney who is versed in constitutional law to review the process that has happened here, to review this investigative report, to advise you on whether the personnel policies apply to Mr. Lovell, to advise you on whether they think due process was followed here, to advise you on whether you think his constitutional rights have been violated. If the commissioners took a different course from here on out, that might impact what Commissioner Lovell decides to do. But I know I have said some very strong words here today, but I feel very strongly in this case. I don't think I've ever seen a case where it was constitutional rights so clearly violated. So I'm happy to answer any questions you might have. Otherwise, that concludes my comments.
Yeah, I don't think at this point we'll have any back and forth, but thank you. Commissioner Lovell?
Thank you, Chair. At this point, I could go with the report and give you my version of my side of the story. I don't know if that's appropriate at this time. We do have a lot of questions to answer procedurally and constitutionally here. If the public, I believe the public's right to know what my side of the story is, and I've got a number of things I cite in the report that are factual inaccuracies that I think the public needs to know. And if this is the place and venue for that, Chair, I'm happy to continue.
Use the floor to your discretion.
All right, well, thank you, Chair and Lane County Board, for listening to this report that I have and the results. It's important to note there are glaring fact discrepancies, intent questions that I have to why certain information was released and its timing, plus there are actual damages these alleged sustained claims say exist. My responses to this investigation report will reinforce these facts. Elected officials are not subject to employee discipline. Standards or policy, we are subject only to the voters, as my counsel has described. They decide by casting their vote if how we are conducting ourselves is in line with their desires. I work for them, not an administrator. The First Amendment guarantees freedom of speech, freedom of religion. As a citizen of this country, even if I'm an elected official, I'm guaranteed these rights also. What I say you may not like, it may even offend you, yet it doesn't make it actionable to some policy arbitrarily applied. The investigative report was hurriedly put out into the public by staff who inserted themselves into the political process without formal board representation or presentation or authorization, with known factual errors the outside hired county counsel knew and the county administrator knew, allegedly. Its intent was not for transparent communication, but for maximum damaging effect to a sitting commissioner. It was erroneously stated in the public investigation was released with, quote, a vote from the Board of Lane County Commissioners. I never saw that vote. Who authorized its release? It appears as if ad hoc decision was made by the board, and if so, that's a blatant disregard to Oregon ethics and a violation. Looking at the investigation, bear in mind there is no crime, zero actual damages to any alleged victims, no clear definition of the standards of retaliation other than the disdain to words and false accusations as to my intentions. On May 7th and May 29th, there is a quote now used as gospel that is vaguely reported by the words to the effect, unquote, that are on the investigation, meaning interpretation, memory, and embellishment are part of this claim. In the off-campus, off-record meeting requested by stated employee 1, I stated clearly in the discussion when the context of the subject comment was brought up that it was not my words, but words that were discussed between members of the community who had witnessed that presentation that bothered them. Subsequently, after the HR complaint was filed, employee 1 and I had a Zoom meeting to clarify and discuss feelings about the situation, where again, I stated the context and that employee 1 had misrepresented the reference origin. After a series of humble apologies by me and mutual agreements of how the comment could have been taken out of context, we agreed to a mutual understanding and how to discuss the matters going forward. Such so that employee 1 said at the end of the call, and I quote, "I thank you for the apologies and for your humility in talking with me about this matter," unquote. This matter was handled discreetly, professionally, and completely as to protect the community member mentioned or referenced and according to the standards of Lane County policies. This event should have never seen the light of day ever again, except when the county administrator thought to take this confidential matter into the public arena when I was out of the country to Africa. My burning question is to his intent. Why inflict this kind of unnecessary collateral damage to a community colleague just to make an inaccurate point about me? Factual error number 1. For the record, stripper on a strip pole is not a comment stemming from me. It was a context of a discussion with others. June 13th, 2025 conversation is framed that I knew of family religious trauma before I signed a birthday card with well-wishing comments. "Thanks for doing kingdom work. Blessings, Commissioner Lovell." This is categorically untrue. Lane County has developed a robust diversity, equity, and inclusion program that at its core is designed to have an adaptive approach to where everyone can come to work with, quote, their authentic self. We've discussed this many times as a board. And right now, outside of a commissioner's office is a rainbow carpet. Once a year, the county administrator has an ashen smudge on his forehead a week before Easter. Yet due to complaint methods like this birthday card crime, we now have people wearing crosses in our organization now under their shirts, and we no longer distribute birthday cards as a goodwill offering to our employees because no one wants to be incurred or accused of having trauma being pushed on someone else. Factual error number 2. The person receiving the birthday card encouragement is a known pastoral family I've known for over 20 years. This estrangement was not known prior to my signing, and to say this was somehow malicious or harmful in any way is ludicrous. Factual error number 3. The county administrator repeats this claim as to my own comment and not one of contextual conversation among parties in his testimony on a second meeting of June 23rd, 2025. Factual error number 4. On June 16th, employee 1 claims we met at a community event where my response was not to comment on something they asked me. This never happened. On the date it mentioned, I had a Zoom meeting taken in my office with employee 1 and a Ms. Laura Pancos to be updated on the effect of state funding shifts that would have on Health and Human Services matter. Further, my refusal to comment to any staff inquiry is not retaliation, but discretion as to how I do my job. To say that I should not meet with employee 1 on future H&S matters is a major mission creep. Factual errors 5, 6, 7, and 8. The sustained accusations, I use that in quotes because about meetings canceled with Administrator Mokrzycki. First, these meetings with both the administrator and schedules and the changing dynamics of the job of being a commissioner shuffle all the time. Specifically, according to the report, factual error number 5 on July 9th, 2025, cancellation was due to my returning back from a trip to Africa a few days prior and being emotionally subjected to near daily phone calls with outside counsel pertaining to these events. A cooling off period to skip the meeting was recommended by that counsel. Factual error number 6, July 23, 2025, the cancellation, I had an outside meeting conflict and wished to reschedule. Factual error number 7, August 25th, 2025. The meeting was scheduled in my office, and Mr. Mokrzycki was a no-show. I was there. Factual error number 8, September 8th. The meeting was scheduled in my office, and once again, Mr. Mokrzycki was a no-show. I was in my office. Factual error number 9. Reportedly, according to the full investigative report, Human Services Director erroneously documented my previous scores of performance were given by me toward the county administrator to falsify and justify retaliation. According to the HR director, who doesn't have supporting documentation, stated I gave Mr. Mokrzycki a 2 grade in 2024, when in fact a 1 grade was given in 2024, and a 1 grade was given in 2025, and a 2 grade was given in 2023. These scores are not retaliatory, but consistent. Factual error number 10. August 25th, 2025, claim I used the word stripper while discussing complaint dynamics during the Captive Audience podcast is fabricated. A transcript search of that interview revealed the word was never used. Factual error number 11. My email to Mr. Mokraheiski's email release of client-attorney privilege and executive session discussions into the public of alleged workplace conduct concerns spanning a multi-year period, unquote, is a response. The other side of the story, and categorically is part of my job. It is careless and a factual stretch to categorize this into the loose retaliation parameters being established here. A couple of questions I still have. If my relationship with the county administrator is supposed to be one of workable respect, why is it that the board recommended that we get a mediator between the two of us that I happily agreed to and put the request on the county administrator's desk, where it laid for 2 weeks until he decided it was not worth his time? That's a choice he made, and that affects his performance. Other things that affect his performance are the changes in the draft contract I have here on the Clean Lane project. 2 key paragraphs shifted liability off of a shared liability contract and story that this board was told and voted on into one where the county suffers all of the liability on a $174 million contract, an amount of money that could potentially bankrupt the county. We were not informed of that before a second vote. I would assume and bet that the board would have voted very differently having known this information. There's other things about land use debacles and material requirements that we have about this contract that have not been passed to the board. That is part of the administrator's job. So I hold that also in his performance review. That's what I have to say today, Chair. Thank you.
Okay, thank you. Well, Counsel Klein, I'm looking for some direction here.
I recommend that we transition into executive session under 192-662F, as was noticed.
Okay. The Board of County Commissioners will now meet in one executive session. The session is to consider the dismissal or disciplining of, or to hear complaints or charges brought against a public officer, employee, staff member, or individual agent who does not request an open hearing. And to consider information.
Mr. Chair, that's not the reason for this next executive session. That was for in case Mr. Lovell wanted to have what he just said in executive session. So really the reason for executive session is only the number 2 that you're going to read. Sorry.
Okay, well, that was my script, so.
Sorry about that. I just wanted to make it clear on the record. It's not your fault. It was on your script, but
Right.
we didn't use an executive session for that first purpose. So I just want to make it very clear on the record. Thank you.
Okay, so they're exempt by law from public inspection. It is held pursuant to ORS 192-660-2B and ORS 192-660-2F, which allows the Board of Commissioners to meet in executive session for purposes listed. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are precluded from attending. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. Members of the news media are not allowed to tape, video record, or otherwise record an executive session. Verbatim notes are prohibited. No decision may be made in executive session. The Board of County Commissioners may return to public session in Harris Hall at the conclusion
Chair,
of
I have a question.
executive session.
Is the board going to proceed to executive session even though Commissioner Lovell requested an open hearing on this?
Well, that was why I asked Counsel Klein, because I don't know if we go into executive session or we remain in public session
Chair,
legally.
Chair, my recommendation is that we go into executive session under ORS 192-6602F to consider records that are exempt from public records law, and to consider records that are attorney-client privileged. And that session should be in executive session. And then the session that we just had was under ORS 192-6602B, which was conducted in open session pursuant to Commissioner Lovall's request.
Chair, we haven't had the open meeting that Commissioner Lovell has requested. That can't happen until he gets the full investigative report and the evidence. He didn't fully defend himself today. He defended himself against the 11 pages he has. He doesn't have the full investigative report. So the open meeting he's requested hasn't happened, and it cannot happen until he gets the evidence against him.
I see what you're saying. Lori, what are your thoughts on this?
Chair, I advise we go into executive session and we can give legal advice. I have a memo that we can talk about that when we go into executive session.
And we will not be in executive session for the 2B as you were speaking at, Jose. So, okay. Does that clear we're allowed to go into executive session right now, Lori?
Yes.
Okay. We will adjourn and go to BCC conference room. County Board of Commissioners meeting for February 18th, 2026. To you, Jose. Excuse me, we've been in executive session a long time. Council Klein.
So now we are transitioning back into open session to for a motion from the body has any motions. Lori, if there's anything else that needs to be.
No, that's fine. And did the board receive the email?
Yeah.
Okay.
Okay. Do we have a motion?
Chair, I move that we direct staff and attorneys to prepare a statement of unity for those reporting discrimination and harassment for adoption at the next regularly scheduled board meeting, and that Commissioner Lovell issue an apology that acknowledges the harms of people affected and acknowledges the sustained allegations in Mountain Lake's employment investigation, and issue that no later than our next regularly scheduled board meeting in coordination between you and his attorney.
We have a motion. Do we have a second?
I will second.
We have a motion made to direct staff and attorneys to prepare a statement of unity for adoption at the next regularly scheduled board meeting, and that Commissioner Lovell issue an apology that acknowledges the allegations sustained in the Mountain Lakes employment investigation and acknowledge the harm caused to the people affected. Do we have any conversation for the motion? Commissioner Lovell.
Thank you, Chair. Yes, I do. As my understanding, the executive session going forward was about a legal memo discussion, not about imposing any disciplinary proceedings on that. So in my view, this executive session you just completed was misrepresented and misfiled or misagendized, if that's a word I can use. I voluntarily left the meeting under objection because there was assurances that disciplinary motions and thoughts were not going to be discussed, and here we are with a motion on the table. So I strongly object to this motion, and I believe that it was that the discussions in the executive session violated ethics laws.
Any further discussion? So far.
Thank you. I'll respond to that. In my opinion, there was no disciplinary action discussed during this meeting. During the executive session, no disciplinary decision was made. The motion as stated was subject to, it was an advice to you, Commissioner Lovell. It wasn't a disciplinary action. So it's a suggestion for you to take action, not for the board taking any action against you.
Any further discussion? Any other first rounds? Commissioner Lovell.
Thank you, Chair. At this point, I'd like my counsel Jill Gibson to weigh in if she so desires. I'd like to invite her to the table if she feels it's appropriate.
I would have to ask legal counsel about that.
For Lori on that.
It's not really a public meetings issue. It's up to the board as to whether what they want to hear from Commissioner Lovell's legal counsel. I don't think, well, it's up to you. There's no action to be taken except the motion that's on the table. And this is discussion period, and the board has prerogative to do what it wants during this discussion period, as long as it's directed towards the motion that's on the table or the direction that's on the table.
I'll look for head nods if we would like to hear from Jill about the motion that's on the table.
Chair, my thought on that is that there'll be plenty of opportunity for legal counsels to weigh in based upon the motion subsequent to presuming the passage of the motion. There'll be plenty of opportunity between now and the next regularly scheduled board meeting. So my preference is to move forward with the vote.
Okay, well, it doesn't look like we have head nods for that. Then I will state that I will not be supporting this motion. I believe this process has been flawed since the start, and I think the county has issued some bad advice, and I have concerns about our liability at this point. I will call for the vote. All those in favor signify with an aye.
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 All those opposed?
Nay.
Motion passes 3-2 with Lovell and Senega negative. Anything else? This meeting is now adjourned.